All states have citizenship, residency, and age requirements for voting. Other voting requirements differ from state to state. Some requirements, especially those that are used to disenfranchise certain groups, have been eliminated over time. Here is some terms you need to know: transient, registration, purge, poll books, literacy, and poll tax. Universal requirements. Today, every state requires that any person who wants to vote must be able to satisfy qualifications based on 3 factors: 1, citizenship; 2, residence; and 3, age. The states have some leeway in shaping the details of the first 2 of these factors. They have almost no discretion with regard to the third one. Aliens, foreign-born residents who have not become citizens, are generally denied the right to vote in the United States. Still, nothing in the Constitution says that aliens cannot vote, and any state could allow them to do so if it chose. At one time, about a fourth of the states permitted those aliens who had applied for naturalization to vote. Typically, the western states did so to help attract settlers. Only one state now draws any distinction between native-born and naturalized citizens with regard to suffrage. The Minnesota Constitution requires a person to have been an American citizen for at least 3 months before he or she can vote in elections here. In practice, a few aliens do vote, though in what number no one knows. They either wrongfully believe that they are citizens or unlawfully claim to be citizens at their polling places. In order to vote in this country today, one must be a legal resident of the state in which he or she wishes to cast a ballot. In most states, a person must have lived in the state for at least a certain period of time before he or she can vote. The states adopted residency requirements for 2 reasons. 1, to keep a political machine from importing or bribing enough outsiders to affect the outcome of local elections, a once common practice. And 2, to ensure that every voter has at least some time in which to become familiar with the candidates and issues in an election. For decades, all states imposed a comparatively lengthy residency requirement. They typically mandated at least a year in the state, 60 or 90 days in the county, and 30 days in the local ward or precinct. Resident requirements for voting are not nearly so long today. The details vary, but only slightly, among the 50 states. Nearly half of the states now require voters to have lived in the states for at least 30 days. In several states, the period is even shorter. For example, the requirement is only 20 days in Delaware and Oregon, 15 states in South Dakota, 14 days in Kansas, and 10 days in Alabama and Iowa. Arizona does have a 50-day rule, but it is the only state in which a new resident must wait for more than 30 days to become an eligible voter. A growing number of states now require a voter to be a legal resident of the state, but attach no time period to that requirement. Today's much shorter requirements are a direct result of a 1970 law and a 1972 Supreme Court decision. In the Voting Rights Act amendments of 1970, Congress banned any requirements of longer than 30 days for voting in presidential elections. In Dunn v. Bloomstein, 1972, the Supreme Court found Tennessee's requirement at the time, a year in the state and 90 days in the county, unconstitutional. The court held such a lengthy requirement to be an unsupportable discrimination against new residents, and so in conflict with the 14th Amendment's Equal Protection Clause. The Supreme Court said that 30 days appears to be an ample period of time. Election law and practice among the states quickly accepted that standard. Nearly every state does prohibit transients, or persons living in the state for only a short period of time, from gaining a legal residence there. Thus, a traveling sales agent, a member of the armed services, or a college student usually cannot vote in a state where he or she has only temporary physical residence. In several states, however, the courts have held that college students who claim the campus community as their legal residence can vote there. The 26th Amendment, added to the Constitution in 1971, declares, quote, "The right of persons of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or any state on the account of age." 26th Amendment. Thus, no state may set the minimum age for voting in any election at more than 18. In other words, the amendment extends suffrage to citizens who are at least 18 years of age. Notice, however, that any state could set the age at less than 18 if it chose to do so. Until the 26th Amendment was adopted, the generally accepted age requirement for voting was 21. In fact, up to 1970, only 4 states had put the age under 21. Georgia was the first state to allow 18-year-olds to vote. It did so in 1943 in the midst of World War II. Kentucky followed suit in 1955. Alaska entered the Union in 1959 with voting age set at 19, and Hawaii became a state later that same year with a voting age of 20. Both Alaska and Hawaii set the age above 18 but below 21 to avoid potential problems caused by high school students voting in local school district elections. Whatever the fears at the time, there had been no such problems in any state since the passage of the 26th Amendment. Efforts to lower the voting age to 18 nationwide began in the 1940s during World War II. These efforts were capped by adoption of the 26th Amendment in 1971 during the war in Vietnam. That amendment was ratified more quickly than any other amendment to the Constitution. This fact is testament to the emotional weight of the principal argument in its favor: old enough to fight, old enough to vote. How have 18 to 20-year-olds responded to the 26th Amendment? In 1972, 58% of that age group registered to vote, and 48.4% of them reported that they did vote that year. By 1996, however, the registration figure had dropped to 45.6%, and only 31.2% said they actually went to the polls. Contrast the turnout of those young people with that of Americans 65 and older. In 1996, 77% of them were registered, and 67% voted. Indications are that the low turnout behavior of 18 to 20-year-olds continued into modern times. In a growing number of states, some 17-year-olds can now cast ballots in primary elections. Those states allow anyone whose 18th birthday falls after the primary before the general election to vote, be able to vote in the primary. One state, Nebraska, has become very close to effectively lowering the voting age to 17 for all elections. There, any person who will be 18 by the Tuesday following the first Monday in November can qualify to vote in any election held during that calendar year. Other qualifications. The states have imposed a number of other qualifications over time, notably requirements based on literacy, tax payments, and registration. Only registration has survived as a significant requirement. 49 states, all except North Dakota, require that most or all voters be registered to vote. Registration is a procedure of voter identification intended to prevent fraudulent voting. It gives election officials a list of those persons who are qualified to vote in an election. Several states also use voter registration to identify voters in terms of their party preference, and thus their eligibility to take part in close primaries. Voter registration became a common feature of state election law in the early 1900s. Today, most states require all voters to register in order to vote in any election held within the state. A few do not impose the requirement for all elections, however. In Wisconsin, for example, only those in urban areas must register to vote. Typically, a prospective voter must register his or her name, age, place of birth, present address, length of residence, and similar facts. The information is logged by a local official, usually a registrar of elections or the county clerk. A voter typically remains registered unless or until he or she moves, dies, is convicted of a serious crime, or is committed to a mental institution. State law directs local election officials to review the list of registered voters and to remove the names of those who are no longer eligible to vote. This process is known as purging, and it is usually supposed to be done every 2 or 4 years. Unfortunately, the requirement is often ignored. The poll books in those places are cluttered with a large number of persons who no longer meet voting requirements. Poll books are the lists of all registered voters in each precinct. The registration requirement for voting has become controversial in recent years. Some people argue that it should be done away with. They view registration as a bar to voter turnout, especially among the poor and the less educated. Those critics buttress their case by noting that voter turnout began to decline in the early 1900s, just after most states adopted a registration requirement. They also point to the fact that voter turnout is much higher in most European democracies than in the United States. In those countries, voter registration is not a matter of individual choice. By law, public officials must enter the name of all eligible citizens on registration lists. The United States is the only democratic country in which each person decides whether or not he or she will register to vote. Most people who have studied the problem favor keeping the registration requirement as a necessary defense against fraud. However, they also favor making the process a more convenient one. In short, they see the problem in these terms. Where is the line between making it so easy to vote that fraud is encouraged and making it so difficult that legitimate voting is discouraged? Most states have eased the registration process over the last several years, and in 1993, Congress passed a law that required every state, but North Dakota, to do so. That law, dubbed the Motor Voter Law, became effective in 1995. It directs every state to 1. Allow all eligible citizens to register to vote when they apply or renew a driver's license. 2. Provide for voter registration by mail. And 3. Make registration forms available at the local offices of state employment, welfare, and other social service agencies. The Federal Election Commission reports that by 2000, some 8 million persons had registered to vote as a direct result of the Motor Voter Law. The law also requires every state to mail a questionnaire to each of the registered voters every 4 years, so that the poll books can be purged for deaths and changes of addresses. It also forbids the states to purge for any other reason, including failure to vote. Wisconsin allows voters to register at any time, up to and including Election Day. Elsewhere, a voter must be registered by some date before an election, often 20 or 30 days beforehand. That cutoff gives election officials time to prepare the poll books for an upcoming election. Literacy. Today, no state has suffrage qualifications based on voter literacy, a person's ability to read or write. At one time, the literacy requirement could be, and in many cases was, used to make sure that a qualified voter had the capacity to cast an informed ballot. It also was used unfairly in many places to prevent or discourage certain groups from voting. For many years, it was a device to keep African Americans from voting in parts of the South, and Native Americans and Latinos from voting in the West and Southwest. Some literacy requirements call for potential voters to prove that they had the ability to read. Other states required proof of the ability to both read and write. Still others required the ability to read, write, and understand some printed material, usually a passage taken from the state or federal constitution. Often whites were asked simple questions. African Americans were asked questions so complex that they would stump even a judge who was familiar with the passage. Connecticut adopted the first literacy qualifications in 1855. Massachusetts followed in 1857. Both of these states were trying to limit voting by Irish Catholic immigrants. Mississippi adopted a literacy requirement in 1890, and shortly, most of the other southern states followed suit. Southern literacy qualifications usually included an understanding clause, again, requiring potential voters to demonstrate comprehension of some printed material. While those qualifications had been aimed at disenfranchising African Americans, they sometimes had unintended effects. Several states soon found that they needed to adjust their voting requirements by adding a so-called grandfather clause to the constitutions. These grandfather clauses were designed to enfranchise those white males who were unintentionally disqualified by their failure to meet the literacy or tax-paying requirements. A grandfather clause was added to the Louisiana Constitution in 1895. Alabama, Georgia, Maryland, North Carolina, Oklahoma, and Virginia soon added them as well. These clauses stated that any man or his male descendant who had voted in the state before the adoption of the 15th Amendment in 1870 could become a legal voter without regard to his literacy or tax-paying qualifications. The Supreme Court found the Oklahoma provision, the last to be adopted in 1910, in conflict with the 15th Amendment and Gunn versus the United States in 1915. A number of states outside the South also adopted literacy qualifications of various sorts. Wyoming did so in 1889, California in 1894, Washington in 1896, New Hampshire in 1902, Arizona in 1913, New York in 1921, Oregon in 1924, and Alaska in 1949. Its unfair use finally led Congress to eliminate literacy as a suffrage qualification in the Voting Rights Act amendments of 1970. The Supreme Court agreed in Oregon v. Mitchell, 1970. Quote, in enacting the literacy test ban, Congress had before it a long history of the discriminatory use of literacy tests to disenfranchise voters on account of their race. End quote. Justice Hugo Black, opinion of the court. At the time Congress banned literacy tests, 18 states had some form of literacy requirement for voting. Tax payment. Property ownership, proved by the payment of property taxes, was once a very common suffrage qualification. For decades, several states also demanded the payment of a special tax called the poll tax as a condition for voting. Those requirements and others that called for the payment of a tax in order to vote have disappeared. The poll tax was once found throughout the South. Beginning with Florida in 1889, each of the 11 southern states adopted the poll tax as part of their effort to discourage voting by African Americans. The device proved to be of only limited effectiveness, however. That fact and opposition to the use of poll tax from within the South as well as elsewhere led most of the states to abandon it. By 1966, the poll tax was still in use only in Alabama, Mississippi, Texas, and Virginia. The 24th Amendment, ratified in 1964, outlawed the poll tax or any other tax as a condition for voting in any federal election. The Supreme Court finally eliminated the poll tax as a qualification for voting in all elections in 1966. In Harper v. Virginia Board of Elections, the court held the Virginia poll tax to be in conflict with the 14th Amendment's Equal Protection Clause. The court could find no reasonable relationship between the act of voting on the one hand and the payment of a tax on the other. Clearly, democratic government can exist only when the right to vote is very widely held. Still, every state does purposely deny the right to certain citizens. For example, none of the 50 states allow people in mental institutions or any other person who has been found legally to be mentally incompetent to vote. Nearly all states also disqualify those who have been convicted of serious crimes. A few states also do not allow anyone dishonorably discharged from the armed forces to vote.